Good afternoon, everyone. We're just going to wait for a couple of minutes while attendees join us. Um, Thank you for your patience. Please bear with us. Good afternoon, ladies and gentlemen. I would like to welcome you to our webinar series on Labor Codes 2020. In our session last week, we covered the implications of labor codes for manufacturing firms. Today, we will be covering the implications and challenges of labor codes for service organizations. Before moving ahead, I would like to give you a brief about ASA and our speaker today. ASA is a 3-decade-year-old accounting and consulting firm with a team of over 700 professionals spread across 8 offices in India. A major part of our focus is on foreign companies setting up and operating in India. Today, we are one of India's foremost accounting and consulting firms, assisting our clients in setting up their businesses, mergers and acquisitions, partner search, risk advisory, taxation, compliance issues like accounting, payroll, IFRS, etc. I would like to introduce you to our speaker today, Himanshu Srivastava. Himanshu heads our business advisory services vertical at ASA. His responsibilities include end-to-end business strategy and project management services. He is an active speaker at national and international fora on topics ranging from doing business in India to exchange control regulations, corporate and industrial laws. Before we begin, here are a few instructions for the webinar. Please note that all participants will be in listen-only mode throughout the webinar. If you have any questions or comments, please put them in the question section of the chat box. The presentation will be followed by a Q&A session. A link to this recording of this particular webinar will be emailed to you tomorrow. If you have any questions, please reach out to us. Thank you, and over to you, Himanshu.
Thank you, Kim. Thank you, my colleagues, for putting this up, and thank you very much, audience, for sparing time today. As Kim has already informed you, today's topic is specifically on the impact of the new labor regulations, the expected rules, and the codes on the service sector. So broadly, the regulations are, uniform all across the sectors, but we have selected carefully what are the finer points and nuances which a service sector organization or establishment, including the management of service sector organizations and the, let's say, in charge on the HR divisions should pay consideration to while preparing themselves for the labor codes. So I would request my colleagues to help me, and I will go to the next slide. Yeah, so just a brief introduction why we decided to choose this topic as to be talking about service sector as well. Although manufacturing, takes a lot of limelight because it's one of the key sector where the government of India is key to promote India as a manufacturing hub. But nevertheless, on the ground, the fact remains that India is known for its soft power, and there are certain statistics which I collected from resources in the public domain. So as we all know that India is export hub of IT sector, and we are known as leaders in IT services. And surprisingly, service sector accounts for nearly 48% of our exports. And despite the pandemic, the sector is showing very moderate signs of growth for the next 2-3 years. Besides these issues, there's a huge market of $9.6 billion. And then surprisingly, last year, one of the key sector which has shown a remarkable growth in terms of FDI is service sector. And when I say service tax sector, it encompasses any and all the sector except the manufacturing, be it telecommunication, or health services, IT services, and other such, where there's an element or other sector can be driven by services. So in terms of total share in the economy of India, 55% of gross value added is contributed by the service sector. And last point would be that of late, because of the challenges which we are all going through, the pandemic, and even before that, the startup ecosystem has been showing good signs of proving India's prowess. So we already had 38 unicorns and more being added. Specifically 11 I'm aware of, but I thought maybe by the time this presentation would come up, the statistics would have changed and we may have more unicorns in India. So glad. So this was a background on the service sector. Now we'll straight away jump into the labor codes. Next slide, please. So this is the background, and I think if you have attended any of our sessions in past few weeks, you may have seen this slide, and I purposefully keep it as a platform or as a background of our discussion. Is that we all know that labor was one such key issue which was highlighted in every forum, that how difficult it is to maneuver the HR or the labor regulations in India. And rightfully so, the government did take necessary action. But for this pandemic which struck all of us, and we were caught unaware. But this is a very much need of the hour, and the government also was thinking on these lines. And in 2019 itself, the first wage code came in. So all these labor laws or legislations or modification that being done piece by piece basis were all crystallized into 4 labor codes. One was wage code. 4 laws were combined: occupational safety and health. 13 laws were merged. Industrial relation, very important, 3 laws were merged. And specifically, so social security, 9. So roughly, all these legislation which were governing the management of labor or human resource, or related to safety and health measures or payment of wages, were actually very beautifully carved into 4 major codes: wage code, occupational safety, industrial relations, social security. And one of the key feature of these codes is that there is a uniformity in all the 4 codes. These 4 labor codes are really not contradictory to each other. Some codes may have certain additional requirement, but you cannot find an incidence where one code is and 2 different codes are really talking 2 different things. So in a way, it's a very good step, and I'm sure it will ease doing business in India. And as a consultant or as entrepreneurs, you might have faced these challenges, but I'm sure once these codes and the rules are notified, the law were notified, the codes were notified last October, and with a caveat that the rules, because labor is a matter which is governed by both central and state, so the law has been announced by the government. It is uniform pan-India, but states have powers to announce their respective rules. So for last 3-4 months, there has been speculation as to when these would actually be notified and and be effective. But however, let me admit that there is no certainty, or I cannot for sure say that by this date this will be approved, as we are all suffering from unprecedented times. It is quite uncertain right now, but I can tell you that many of the states such as Uttar Pradesh, Jammu and Kashmir, Himachal, they have really announced their rules. And once they receive feedback from the public and they take into account while drafting the final versions, and it will be out. So all, for all your information and reference, I would say that assume that they will be effective 1st of April. And as we all know, there is a concept which is very favorite with Indian regulators called retrospective effect. So I'm sure that whenever these codes are coming or rules are coming, they make sense, to be applicable from 1st April, because you would not have 1 month under a different law and 11 months under a different law. So as a measure of prudence, do factor in that, despite the fact that we are going through a very turbulent times, but as far as compliances are concerned, this is the fact and paperwork, and which has to be in order. So please do take notes of these points which we're going to discuss today. They may not be coming with a deadline as of today, but maybe tomorrow or next week they will be announced and they will become the law. So please, if you have any questions, do approach us, and I'll move on to my next slide now. Yeah, so technically, why are we discussing this? There are certain regulations, or so to say legislation, laws which have been announced. These laws are impacting our compliances, something that we are bound by the law of the land to adhere to, besides as our own zeal to be fully compliant. These are important changes that have to be taken into consideration when you make your strategy and plan for the coming year. And these are going to be reported to the government, as we would see in the slides, that the government play a very critical role in hand-holding to the entrepreneurs and to the employees in successful and effective implementation of these labor codes. So that's a very important element. We are not doing it just for our own internal happiness. This is all going to be reported. And last and most important is employees, that employees need to be aware of their duties as well as rights, and both employer and employee are essential for success of an organization or for a business mission. Therefore, it is important that both parties understand their mutual roles and responsibility, and the overall impact is factored into the HR policies as well as corporate governance policies of the organization. And therefore, we are discussing it. How it is going to impact each organization may vary, but for sure it is going to impact us all, because as you would see in the slides that are going to come up, is that the very basis of HR compliances starts with the registration number, which is going to be allotted under the new code by the government, and that number has to be like, for example, PAN number. For all income tax documentation purpose, that code under the labor code will be quoted on all HR related documentation, for example, employment agreements or offer for letter or returns. Next slide, please. Yeah. So wage code, there were these 4 major wage related laws were merged into the wage code: Payment of Wages Act, Payment of Wage Act 96, sorry, this is a duplication, Bonus Act and Equal Remuneration Act. Next slide. Minimum Wages Act was the second one. Next slide. Occupational Safety and Health Working Conditions Code 2020 subsumed all these 13 codes. They have taken all the related occupational safety, health and welfare measures from each of these acts, such as factories, mines, and as you can see, there are flavors of various acts, including journalists, motor transport, sales promotion, senior workers. So everything has now been merged, and the government is trying to be uniform for all the sector. Of course, there are specific sections which are not applicable. Let's say journalist section may not be applicable to dock worker, mines may not be applicable to factories, but then the way the law has been structured is that it would definitely ensure good understanding and good implementation. Next. Code on Social Security, as we all can see, it pertains to benefits and social security benefits to the employees, and 9 such pieces of legislation have been merged. Next slide. So, just to kind of recap is that you have seen that 4 in wages, 13 in OSH, and then 9. So in a way, and I have not purposefully covered the industrial relation code because it is primarily towards the industry and manufacturing. But as you can see that all this is, really leading us to why and how do we understand the impact. So when we read these codes, what we are going to present to you is that we primarily see that these codes have a financial impact, a huge impact on the operations. Of course, the regulatory is, and not to be missed, a piece of the whole equation, and the functional impact. And we have tried wherever possible to highlight these operational impact in the coming slides. Next slide. Yeah. So first and foremost, what constitutes an employer and employee relationship is a promise to render services in exchange of wages. So, and the very definition of wages has been changed in the code. So what wages include is these 3 things: basic pay, DNS allowance, and retaining allowance. What wages do not include are these headings. So you have left side of inclusion and right side of exclusions. So if the exclusion exceeds 50% of the total wage, means left and right combined, the amount that exceeds the 50% shall be added to the remuneration, and the wages will be calculated at 50%. I will explain it in more detail in next slide. Next slide. So this is how you can understand that this change in definition is going to impact. I've taken a very simple example, and I've taken purposefully taken 30,000 rupees of salary of an employee, which could be moderate for a medium level employees in any organization. Is that there's a basic pay, DNS allowance, and retaining allowance. And then there are certain other allowances such as special allowance, house rent allowance, and conveyance allowance. So you can see that in this example, 15 and 15, they are equal. So to take a very simple example like this, under the old Provident Fund Act, how wages were calculated were basic plus DA. So it was actually at 12,000. However, under the new wage code, you can see the wage I've calculated in, and it's been highlighted in red. It's actually coming out to be calculated at 15,000. So there's going to be impact on Provident Fund calculation, and in my view, the calculations or the cost to the company might increase. In case of Gratuity Act, as you can see, basic salary plus DA, in my view, again, the impact is going to get increased. And there was a tendency also, as we all know, to keep the basic at very low, so that these benefits were actually, not impacting the organization that much. Minimum Wages Act, calculated the wages to be 22,000. However, now it has been calculated 15. Payment of Wages Act, Maternity Benefit Act would be impacted the most because now in this example, the benefit is literally going to get half. So this is how we really need to assess and really sit with our HR department and our HR calculations. And this being the month of April, and I'm sure everyone are busy with their appraisals and new year HR budget. So this is, I think, the most critical time by which you should actually assess that should these labor codes come maybe, let's say, 3 months down the line, how is it going to impact the whole budgeting exercise. Next slide, please. Then there is a definition of floor wages. So the government, what they have done is that in order to create a uniformity pan India, they have decided that central government will announce a floor wage, and state governments are free to decide their minimum wages, which cannot be below the floor wage announced by the central government. So in a way, each state will have to revisit its minimum wage criteria, and we did a comparison of all the minimum wages in all the states and union territories, and we see massive disparities in these minimum wages. So now it is quite essential that we, if at all there are employees, and in some organization which I have really recently been interacting, there are instances where certain section of the employees are actually in the minimum wage criteria. So there's going to be some impact on that particular category, and roughly there were 29 such category. I'm sure the way we are calculating the wages, and specifically under the floor wage, may or may not have equal impact for all organizations, but it is essential that we study and we take necessary action. How do we really pay the wages? I'm sure everyone has a system of paying the wages at certain specified time duration, but under the code, it has been clearly defined that people who you hire on daily basis, and these are not just the labor community I'm talking about. They may be certain employees, or so to say workers, educated, let's say for example, who are people who are hired for a specific job. They, if it is a daily basis assignment, then they have to be paid at the end of the shift. Similarly, weekly basis have to be paid on the last working days. So the government is really putting in place the deadline by which all these claims have to be paid. However, when an employee has been removed, dismissed, or retrenched, or he has resigned, then you have to settle his dues within 2 working days. So in a way, before these things are initiated, specifically removal, dismissal, retrenchment, I mean, of course, you cannot plan resignation, but before you plan these things for any employee, and if not universal, but I know certain organizations who are actually planning to cut the flaps in their organization, so they need to do an advanced calculation, and because the code really talks about 2 working days deadline. Next. Yeah. Payment of dues. Now it is given under the code that when, be it let's say some fine, or deduction due to absence from duty, or value of accommodation given by the employer to the employee, recovery of advances given to the employees, and other things, the deduction cannot be more than 50% of the total wages. And there are very detailed rules around it, but in the nutshell, what I have understood is that you should not deduct more than 50% of total wages on any account. The employee must receive 50% of the total wages. Otherwise, if the deduction exceeds 50%, then the dues, if the employee so wishes and approaches the authorities, then those dues can be recovered legally from the employers. I'm sure these are very rare situations, but then one needs to understand and take measures, and accordingly tweak their systems and guidelines accordingly. And another factor is that you cannot impose fines on the employees without the prior approval of authority. Authority is technically here would mean an inspector having jurisdiction over your area. So all the fines have to be prior approved, and if the authority rejects, then you cannot implement or impose any fine, and there has to be registered, maintained, and the proceeds only can be utilized for the welfare of the employees. You cannot actually be making profit out of it. And then, of course, payment of dues, claims, and audit. There are certain criteria as that up to an employee or the trade union or the inspector can actually raise these claims within 3 years. So it's a very open-ended condition that up to 3 years any claim could come. So you please be very careful about if you have an official request for certain claims, do document it and do maintain a register how you settle these claims in accordance with the regulations. Next slide. So the offenses and penalties, we've just selected some of the offenses and penalties, and minded these are three codes, and they all have very specific penalties for various instances of non-compliances. For example, any employer who pays an employee less than the amount due, and upon any complaint by the employee, there can be a penalty if found true and justify if found true that the amount has been withheld wrongfully. 50,000 penalty can be imposed on the employer, and if further such instances are repeated, then the penalties get more severe. It gets doubled to 100,000 rupees and 3 months in prison, or both. I am sure we all understand that intention of the government is not to make some draconian or dangerous law to hamper the business, but then these measures, I would say, that are justifiable for willful defaulters. Contravention of any provision of the code, first time is 20,000. That's a very steep amount. If, for example, in case of MSME or small entrepreneurs employing let's say 10 workers, this would be a very good, very big impact. And for any repeated compliances, again, the penalties get doubled up. However, the last paragraph, if you are reading, is that only for the first instance, the inspector would give you notice and ask you to correct the default. In repeated or second or third offense, there would be no such opportunity given. So if he, let's say, worst case, and if he really say that, serve 1 month in prison, then it's going to be really stressful how to get out of that. And of course there are procedures of compounding, but then I'm sure no one want to go through that process, and we are all well experienced with the Indian bureaucracy. So please don't take that risk and don't try such adventure. Do document these penalties and do sensitize your HR department about these costs, which technically no one budgets. Next slide. Next slide, please. Yeah, fine. So notice under the wage code. Wage code defines that all organization, I cannot say that we are working, luckily or unluckily, but going forward, whenever your offices are operational, every employer should display on a notice board a summary of the wage code, which can be this presentation as well. That you have to define the summary and educate and give the understanding of the code to the employees. And you also need to train your HR. This is under the code that I'm sure as a director of such company, I would take an undertaking from my HR department that they are fully conversant and they can handle, or my consultant, third-party consultant, that they can actually handle these matters and they understand all the compliances under the code. Then I need to also disclose the category-wise wage rate, wage period, date and time of when I pay my wages to employees. So in a way, it's now important that you create uniform structure. Of course, you can pay differential wages, but within, let's say, a particular band, you may not be able to discriminate, for example, male, female, or similar experience, that, but because that can be again an instance of discrimination and equality. And name and address of inspector cum facilitator, because if any worker or employee want to escalate any concern to the government, then he should be able to contact the authority. So you need to first identify the jurisdictional inspector cum facilitator and then paste it on the notice board. So I personally believe that this would lead to invariably you would end up dealing with the ICF, because conflicts do happen, but it's important that you prepare them and do familiarize yourself with the requirements of the code. Even the employers employing not more than 5 person, for example, agriculture, for example, all of us, maybe with our domestic help and drivers, we should, for future, keep the salary slips and proof of payment on demand. No more cash payments. I would suggest do rather, I prefer RTGS on those accounts, and I would also recommend the same to you. Next slide, please. So then, that was a notice board under the wage code, and this is under occupational safety and health. All you need to define clearly. So you technically may have multiple notices under various codes. All these details you need to inform to the workers, name and address, hours, wage period, date of payment, everything more or less same, and date of payment of wages to unpaid workers. And this notice has to be Hindi, English, and local language. So be mindful of that fact. Next slide. Then there is something on the registration and record keeping, is that although the labor code have been notified last October, and technically this deadline has already passed, but since the portal is not accepting such registrations application, whenever it happens, within 60 days, you need to make an electronic application, and of course with late fee afterwards. And you need to mention all the important information there. For example, details of directors, shareholders, your registered office addresses, the people, number of employees in your organization. It's a long checklist. All that information has to be fed on the portal, and then you will get a registration number. That registration number will be quoted on all HR documents. And I did mention it in the beginning, that all HR document means employee files, employee records, employment agreements, any correspondence on the HR matters with employee. Everything is covered, and therefore you have to be extra cautious on these matters. Then any change in ownership or management or other information submitted has to be updated within 30 days of the change. So it becomes an ongoing exercise that should there is any change in the directorship or any information changes, that you should diligently update it on the portal. And under these the records, there are some additional I've just, because these forms are very exhaustive, and I would request you all to just go through them once. But there's an annual health examination for the employees, which is very, very comprehensive. It's better than mediclaim form of some preventive health service providers. So do refer that form, that what all details you need to get an employee examined in case of various industries, and what all parameters you need to actually report. Then letter of appointment, there's a specific format. I mean, if you have one, I'm sure it is fully compliant, but then just go through it once. Notice of any accident or disease outbreak in your organization, or period of work, and all this has to be registered also in form of certain form 8, 9, and 10, as you can see on the screen. And it is authorized by the law to the inspector cum facilitator that he can issue prohibitionary order and also suggest improvement in certain things, the improvement in the way you do things in your organization, or maybe social distancing, or some safety and health measures. So this can be also made mandatory, or can be dictated by the ICF. So do take care of these issues, and of course this will really change certain aspect of your functioning, and therefore you'll probably need to relook at the whole documentation or the internal control systems in your organization. Next slide, please. Yeah, some more forms. These are again under the Social Security. As you can see, these pertain to Provident Fund or gratuity or maternity. So far, I understand that an email was enough. For example, in case of maternity, so and so is expecting, and she would probably want to go on maternity leaves. But now there are certain processes which have been defined. For example, certificate of proof of pregnancy or delivery, and there's a form to be filled and applied in. And then there are, if there is any complaint against such benefit wrongly taken by any employer, the employer also can complain to the government in Form 12. So you see, in case of a gratuity, you have to fill in Form 3 and 4. And on admission of claim of gratuity, employer has to issue a notice within 15 days of receipt of application that we admit your claim. So that has to be in Form 5, and this form will also be submitted to the authorities. So you cannot just do it backdated. You have to do it as it happens. So please take note of these important changes and update your systems accordingly. Next slide. Contract labor, very important. I think it impacts majority of the organization. However, from the regulation perspective, every establishment in which 50 or more contract laborers are employed or were employed in last 12 months, the code is applicable, and they need to also adhere to such condition. And also, every manpower supply contractor who has employed 50 or more in past 12 months. And this does not include just a staffing company. In my view, it also includes, it can be an EPC company also. It can be a trading company also, which is doing certain jobs on contract. It will be case to case, check it on case to case basis, but I'm quite, from the preliminary view, it looks like everyone is covered. And do factor in, because if you don't have these registration, because a contractor is required to obtain a license. Without a license, it cannot operate, and if it operates without a license, there are severe penalties. And of course, there are certain advantages also to register. So if your organization is also acting as a contractor to your customer, this is equally relevant for you, and please take notice of it. Prohibition of employment contract in core activities. And then exceptions, which is that it's normal for the organization, but that's a very general condition. I will jump on to my next slide, but before that, I'll just say that in case of any seasonal surge, for example, right now, in case of health sector, there might be some seasonal surge, or even the fact that we are dealing with the virus, it may be that they need to work 24/7 and they need to hire more people. So these are falling under the exception rules. Next slide, please. So what are core activities? A core activities is activity for which the establishment is set up. And what are not core activities is defined, these 11 activities can be treated as non-core. However, if your organization is actually dealing in these 11 activities, that becomes your core activities. So in order to protect the employment, and just to ensure that the contract employees and permanent employees are on the same platform, or they have the same entitlement, these provisions have been introduced, but there is no prohibition on engaging contract labor for core activities through contractor. So you can engage contract labor through contractor in your core activity. So the only thing the government is trying to ensure here is that whoever engages contract, if the organization is engaging it in the core activity, they need to ensure that the contract workers or laborers are at the same level as a permanent employee. If the contractor is hiring them, then they have to ensure the same. Next slide. Health, safety, and welfare measures. This is under the occupational safety and welfare measures, and this will have an operational impact on the company. Of course, cleanliness and hygiene, ventilation, temperature, these are universal things. But and of course, drinking water. But there can be specific issues as are highlighted in the headings, that facility for canteen or sitting arrangements, first aid boxes, or medical consumables, or washrooms. They have to be specifically categorized, and I would say that do have a kind of a check, I would say HR audit in your organization, which a person or a competent person can really go through and then just do sort of a record that you have everything in your organization and where these facilities are in the let's say in the office diagram or the map, so that whenever there is an inspection, you can prove to the satisfaction of the inspector that you are adhering and complying with these regulations. The important point is that crèche facilities is now mandatory for any establishment. So there is a specific term called establishment. It includes any kind of employer. And an establishment, you can in simple words understand as one company. So any company in which for 50 or more workers are employed. And I tried to research is that can different branches, for example, one in Delhi, another one in Maharashtra, wherein I have 25. So should this be mandatory on me? So the answer, according to my research, was yes. If you have more than 50 workers in your company, and so you really need to provide for crèche facility for within your organization, or you can actually do a contracting with some third party to avail these services. So I think this is something which was actually expected for long, and now it has become part of the code. So when things get normal, do just keep an eye. And crèche facilities primarily for female workers who have delivered and they have kids under the age of 6. So this might be more relevant there. Next slide. So the some work rule is that I try to summarize. A long regulation is that maximum hours per day can be 8, maximum days of working 6 in a week, and over a week you can do maximum work of 48 hours. So if you're doing it 12 hours a day for 4 hours, you really need to pay overtime to the workers. Of course, or after every 5 hours, you need to give an hour of rest to the workers. So technically, there will be nothing like 8 hours job. It technically should be at least 9 hours if you factor in the resting time as well. Overtime, as usual, can be paid for maximum 125 hours for 3 months and 2 times the rate of wage. Annual leaves with wage, 1 day leave for every 20 days work in a year. And if the worker is discharged or dismissed or he quits employment, you need to pay the wages in lieu of leaves within 1 day. So take a note of this very strict timeline. If the worker retires or dies while in service, then you can settle his dues within 2 months. And most importantly, maternity leaves, layoffs, and annual leaves are counted as work. So technically, you cannot set off these 20 days in the maternity leave. So any holiday falling between the leaves shall be excluded. So this may have some bearing on the way we calculate these benefits for our employees. So take note of it. Leave encashment. If you deny a worker to encash his leave or to go on leaves, then unrestricted leaves can be carried forward. Otherwise, maximum 30 leaves can be carried forward to the next year. Next slide, please. Some organizations which are dealing with some dangerous operations or which have certain operations which may lead to bodily harm, they need to provide some protective gear, or there should be some adequate facilities of, let's say, emergency within the organization to take care of any such situation. You cannot, of course, hire a pregnant women to such operations, and therefore you should obtain undertaking from your female employees, whether they are expecting mothers but before you depute them to such operations. And of course, as an occupier of the factory or the establishment, you need to maintain certain health records of the workers which are engaged in some toxic or hazardous substance, even though this appears to be more applicable on factory. But thinking of trading companies or let's say movers and packers who are handling chemical and toxic substances, this might equally be applicable, and they need to tie up with the right experienced person who knows how to treat this any mishap happen. Next slide, please. Inspector cum facilitator, I think this is like the change in wages definition. This is going to be one of the major impact point, the regulatory impact point, is that we had these labor inspectors earlier also, but the way these laws have been structured, because it is more of a self-reporting, and the government is really trying to do a lot of digital reporting, or doing a lot of digital, talking about digital inspection. Whether or not it is effective, without going into that discussion, I would say that as a compensation to such freedom or such ease of doing business, the government has taken certain aspects and given it to the inspector cum facilitator, that this person is going to have a major bearing on the organization regulatory reporting, is that he has a power to advise the employer and employees relating to compliance of the provision of this code. So this line looks very, very welcoming. In fact, that should be the spirit of the code, I hope. However, if he has any suspicion, which he has no reason to suspect, but if he can inspect an establishment, he can examine a person who's found on any premises whom he believes to be employee of the establishment. Of course, he cannot interrogate your customer, but then if he has a reason to believe that this person is an employee, he can interrogate him or ask him certain question. So maybe you should inform your workers not to give any random declaration to the ICF, because these will be evidences on record. And he can also interview or an employer of the establishment by right, and can make him produce any document or give any information which is in his power, and minded it can be a very confidential and sensitive information. So companies who are very particular about the confidentiality of data about them, about their customer, they need to take note of this important point. Then, irrespective of this interrogation, the ICF can search, seize, or take copies of any record which he thinks is necessary for the purpose of his examination or inspection or audit, for example. So again, a massive risk to organization which have, let's say, IPRs. So I'm going by the worst case scenario. Maybe it's time that you find out third party storage for your important IPR, or all the IPR related documents should be entrusted to a particular level in the organization, and that should be under the safety of a lock and key. So just I can think of various scenarios. You can also imagine specific to your company and take due precautions. And then if there's any abuse of the provision of the law, he can complain to the government. And since he's a public servant, all his actions are considered to be in good faith. So technically, there is no complaint against his actions, which of course is universal to all government servants. But then I think this is an important regulatory impact, and we all need to be very much sensitive about it. Next slide, please. Yeah, confidentiality I've already covered in the previous slide, that if any information which is manufacturing process, commercial business, or working process, be it yours or your customers, if ICF or inspector come facilitator thinks that it can impact the safety and welfare of certain person employed in that factory or establishment, he can disclose it. So then it's important, again stressing the point further, that it's important that you take care of these information. Next slide. Gratuity, even now it is kind of very much mandatory to have these benefits to the employees. Is that a gratuity is paid primarily to all employees who have who completed 5 years of continuous employment, so the provision remains the same. However, this 5 years is not mandatory in case of death or disablement, or which is a new condition called fixed term employment. So if you employ a person for 1 year, then you have to pay him for 1 year. If you employ him for 2 years, then of course, so the amount will be calculated as a gratuity for every completed year of service into 15 days of wages divided by 26 into last drawn wages. So as per example earlier, this last drawn wages would mean 15,000 by the example. Okay, so notice for payment of gratuity, a very important point which I briefly covered, but let me also mention it here, is that an employee who is eligible for payment of gratuity under the code, or any person authorized on his behalf, have reduced certain lines. For example, his legal hire if he is diseased, or if he is authorized anyone because he himself cannot. So it has to be furnished to the employer within 30 days or up to 1 year from the date the gratuity becomes payable. So he has to fill up a form 4 to the employer, and within 15 days of receipt of such application of payment, the employer has 2 options, and he has to document it in form 5 whether he accepts the claim or he rejects the claim. In case he accepts the claim, then within 30 days he needs to arrange for the payment of gratuity. If he rejects the claim, then he needs to inform that also to the competent authority, which could be the regional labor inspector or competent authority as may be notified under the rules. So you cannot just keep silent on these issues. If an employee has raised an issue, you have to reject it, and then the employee is free to contest it in the court of law, and equally the company has to inform to the government. So make no mistake, these compliances become very critical, and proper documentation and record keeping is now very, very critical. So impact, I would say, since I've already mentioned and you have read it, is that contractual worker was being exploited because terms of engagement can be dictated by the employer. But since now it is clearly stated that the terms of engagement of contract workers cannot be less favorable than a permanent employee, these instances will reduce. And these probably were employee retrenchment with sole intention of avoiding gratuity. Maybe this will be addressed, this issue will be addressed, and gratuity can now only be paid through demand draft or bank transfer to the account, not by check or cash. Next slide. So workers, who are actually workers or employees, building workers who are engaged in construction or building, be it managerial, supervisor, administrative capacity. Who are gig workers? Gig worker is a person who is in an arrangement outside the traditional employer-employee relationship, like let's say doing it for a particular project or a particular task. Platform worker, a person using online platform to solve specific issues. Anything, for example, more or less IT specific, or even now under the industry 4.0, certain things can be addressed through AI. Or who are the organized, unorganized worker? So I would say most of us who are attending this session from home are technically organized workers. a home-based worker, self-employed worker, or wage worker in unorganized sector. So home-based workers are technically under unorganized. So although the term is very derogatory, we don't mind it. Who are home-based worker is that a person engaged in production of goods or providing services from his or her home or premises other than employer's workplace. Self-employed worker is a person who engages in self, in unorganized sector, and therefore it becomes necessary that I also define what is unorganized sector and engage in production or sale of goods or services of any kind whatsoever, and where the enterprise employs workers and the workers are less than 10. So wherever the workers are less than 10, that organization technically can be termed as under the unorganized sector. Next slide. The reason I gave you all this long definition was the next slide, is that the welfare scheme will be announced for these category of workers. The central government is responsible for welfare scheme for gig, platform, and unorganized workers, and there will be certain benefits given to them, and government is trying to create a whole ecosystem of social security which will address life and stability cover, health and maternity benefit, old age protection, education, crèche, and any other benefit as may be felt necessary by the government. And state government equally will pay for unorganized workers in respect of provident fund, employment injury benefits, housing, educational scheme for children of these workers, skill upgradation of workers, funeral assistance in old age homes. So as we all can see that it's a good move that the government is really trying to address, I would say, a very non-traditional segment of workers. And given that we boast of being IT superpowers, gig and these unorganized workforce would really, I would say, still does form a sizable or significant section of that, the achievement so far. So I would say that this is a welcome move, and I think this is anybody's guess when these welfare schemes will come. But whenever they are implemented, certainly going to ease, some, let's say, help people to actually prosper. Next slide. So the aggregators, we all know that digital intermediaries or marketplace for a buyer or user of service to connect with a seller. We all know some famous aggregators. We all use them day in, day out. And there are certain classifications such as ride sharing, food and grocery delivery, logistics, B2B marketplaces, whether inventory model or otherwise simple market, wholesale or retail, goods or service, professional service providers, for be it insurance or accounting, healthcare, travel and hospitality, content and media service, and any other goods and services which are provided through a platform. So these are the aggregators. The reason it was important to include this in the slide, that if any one of you is engaged in any kind of aggregator business, or you're employed in an aggregator business, or you know anyone, do tell them that the government has made it mandatory for these aggregators to fund for these welfare scheme, which you were very appreciative of in the last slide, is that not exceeding 2%, but not less than 1% of the annual turnover, of course, excluding GST, will be recovered from these aggregators. So that's a catch, is that I think once these codes become applicable now, and when these welfare measures are implemented, even the government may announce that in this current fiscal year, aggregators will contribute 1 or 2%, and that fund will be separately kept for these welfare schemes as and when they are announced. So something to be watchful of. Next slide. Maternity benefit, we all are aware, but from the point of view of comprehensively addressing the welfare measures. I have listed down these measures. Employment of women for 6 weeks following the date of delivery, miscarriage, medical treatment, or pregnancy is not allowed. A women employee can claim maternity benefits if she's worked at least 80 days out of 12 months prior to expected date of delivery, technically 2.5 months. Maximum period of benefit is 26 weeks, of which a maximum 8 weeks can be availed prior to expected delivery date, approximately 2 months. And then, second last point is something which was new in the code, that every women employee is entitled to 3,500 as a medical bonus. So this probably is some new concept, and you all need to take care of this issue if you don't have any prenatal confinement or such facilities in your organization. An employer with more than 50, I guess, women employee, but the code says 50 employees, should have a crèche facility either separately or you can share common. If you really would go by a very conservative reading, it technically means 50 employees, and you really need to at least on a documentary basis have these crèche facilities identified. Next slide. Career center, again, I think this is something which is still existing but not been very effective. It's kind of an employment exchange, that person seeking employees or person seeking employment, any occurrences of vacancy have to be notified there, and such career center will give vocational guidance to the employees. Next slide, please. So this is broadly the summary of changes, is that as an immediate action, we all need, as stakeholders of our business, be it part of management or employees or divisional head, be it HR, accounting, legal, or dealing with compliances and risk management, we need to do a very comprehensive assessment to check how these codes are going to impact us. I've elaborated certain important points. I'm sure I can tell you there are more. Once you read in more detail, every time you read, you learn something or feel something that yes, this could be also an interpretation. You probably need to overhaul your HR and factory manual system completely, because you need to maintain the documentation in the prescribed format. You need to also introduce certain, for example, certain measures such as health check, and so comprehensively that probably you need now to do an overhaul of your procedures. Increase or decrease in wages may need or may have some bearing on your financial budget or working capital requirement, and it's important that you do a time bound workers to the payment to the workers and contractors. So you really need to assess how your profitability is going to be impacted, and if there are changes which are applicable to you. Foremost, therefore I have highlighted in bold, is that employment motivation. I'm sure 100% of the cases employers don't want to to make the employees disadvantage, take advantage of such regulatory changes only in their favor. But you really need a balancing act, so that you keep the motivation on, as well as you are able to sustain and run your organization. So from that perspective, it is very crucial. And there are certain dispute resolution mechanism. Let's say if you deny anyone benefit of gratuity or maternity or any aspect which we just discussed, how do you address? And there could be valid reasons for that. And of course, it's important that you do familiarize yourself that are you really exposing your management to such non-compliances. Next slide, please. So I was really coming on to this slide, is that all you need to do is you need to answer these 10 questions, and if you think that the answer is not adequate, then you really you are technically are underprepared. So have you done the impact analysis yet? have checked what are the changes going to be impacting your organization? Have you studied, what are the model standing orders, be it for manufacturing or for service? There are service standing orders also for organization which is more than 300 workers. It's going to have some bearing. And let's say companies who are planning some closure, maybe due to pandemic, or reorganization, maybe merging two offices into one, and probably you need to let go of some manpower. Have you thought about these issues? And then, so and so forth. Examine the role of inspector cum facilitators. I think I've already stressed enough or underlined the exposures to the management and confidential information of the companies. So you really need to take care of these issues, which are very, very critical. And profitability, as just mentioned the previous slide, and whole gamut on how this really works in or against you, has to be presented to the management, and they need to take an informed call. We are, of course, working with a lot of our clients and addressing these changes. And trust me, despite the fact that we've been advising our clients for the last 6 months, there are certain very, very specific nuances to each client. And at times we really need to dig deeper or identify an ameliorative measure and how to really cure that anomaly. So there is nothing called perfect world. There's nothing called perfect law. So all you need is to take the calculated risk if at all you want to, but at least it should be really taken with a sound judgment. And of course, if you have any queries, feel free. Slightly overshot the time, but I hope I justified this. Next slide, please. And I guess that's the end of this presentation.
Yes,
thank you very
so
much for your patience.
Thank you. Himanshu, so we've gotten several questions. If you can check your chat group. So one of them was, is there any specific impact on the aviation sector?
Okay. So yes, I would say that there is as I just mentioned, if it is involving any kind of assembly, then, or even this presentation such as service, everything is definitely relooked by these codes, and going, let's say starting from the word employment agreement, taking a registration in the name of the company, be it an aviation or a rail company or a IT company. All these changes are equally applicable on all the sectors. If any organization is under the central government, then slightly the rules are different, but otherwise under the private sector, these impacts are universal.
There was another question on,
yeah.
Sorry. There was another question on where to get the forms that were mentioned.
Oh, these are very well, very much within the rules that were announced. If you would send us your email, we can share it with you. These are part of the codes in the rules.
There were several more questions. One of them is on, it says, in reference to deductions, are companies allowed to withhold payment of remuneration on termination for cause? And on applicability, whether codes or relevant Shops and Establishment Act be applicable, given the welfare measures are addressed by both legislations.
Okay, I'm now seeing the chart. Kim, which number of question is that?
Right down towards the end.
Okay. Okay, fine. So yes, you can, in reference to termination for adequate causes, you can withhold the dues to the employees. That's very much in the code itself. So, for example, just as a random example, if you can deny a person his gratuity if he's dismissed on account of sexual harassment. So it is as severe as that. So there are specific instances where you can actually withhold payment of remuneration to or dues to an employee. On applicability, so when I say that these, I assume I can for sure say that these codes and relevant rules, once these are implemented and notified, these would definitely override all shop and establishment acts, because then there'll be multiple, and all that shop and establishment rules are quite again suffering from this same lacunas and quite archaic. So when these rules will be notified, they would be overriding these shops and establishment act which are applicable from state to state. So, and then yes, there are so many other questions. Sorry, I overshot the time, but then if you would not mind, and if you can send these queries on email, we can prepare very specific short answers to you, and this would also give us a chance to engage in more deeper dialogues with you. Don't mind, please send us an email on, and we will revert to you ASAP.
All right. Thank you so much, Himanshu, for sharing all of those insights during this session. And thank you so much to the audience for staying on for all of this. There were a large number of questions that came in, and we will get back to each of you individually. If there are any further questions, please do not hesitate to contact us. Drop your messages in through email, and we will respond to you. Thank you so much for being on this. The link to the recording of this session is going to be sent to you tomorrow, as will a summary sheet of the codes that were discussed today. As I said earlier, any further questions, please do let us know. Until then, thank you so much. It was a pleasure having you. Thank you so much, Himanshu, for the time and the effort that went into making this. And thank you, everyone. Goodbye.